We are talking about points of differentiation between a company and a firm. And before the break, we talked about transfer of share that in partnership it's not possible, while in the company very easy shares can be transferred from one person to another. Next point of differentiation between a partnership and a company is the number of members. The number of members. There is a legal restriction on a partnership that members or partners shall not be more than 20. If a partnership, if a firm is carrying on running a business, you see, with partners whose number is more than 20, just suppose with 21 and 22, that is an offense, punishable offense. Not only this, but I'm afraid that the firm would compulsorily be, by operation of law, converted into a private limited company. So number of members, the maximum number, minimum is 2 and maximum is 20. While in the case of a company, you see, companies are two types, which you will come to know today: private limited company and public limited company. What are they and what is the difference? Leave it to its proper time. But the minimum number of members for a public limited company is 7 members. 7 members can form a public limited company, and maximum, no limit, unlimited. The entire world population can be shareholders of one public limited company. There is no restriction of the maximum number. While in the case of a private limited company, the number of members is minimum 2, maximum 50. If the number of members in a private limited company goes beyond 50, and their shareholders are 51 or 52, this is also an irregularity which has got some unpleasant circumstances for the company. The company would be automatically, compulsorily converted into a public company, or they will have to reduce the number of their shareholders up to 50. Then there is a lot of differences. You see, I will time and again refer you to partnership law. In partnership, you remember that we said that every partner has got an implied authority, and every partner is an agent of the firm. An agent of the firm means an agent of all the rest of the co-partners. So since he is equal in contributing towards the capital, he is equal in sharing the profit of the business, he should be equal in taking active part in the carrying on the business. So he can act on behalf of rest of them. How? Just suppose that a firm is dealing in selling of rice. One of the partner, he went to Gujranwala, you see, just to attend his nephew's wedding, and there he come across a very cheap rice and he sold it. Is he bound legally to seek the permission from rest of the partners? No, not at all, because he is an agent. He is one of the owners. So he can act, he can buy, he can sell, etc., etc. You see, but movable property. Immovable property, he cannot sell it. Okay. I don't want to take you back to partnership, but this is the position. Coming to the company, for the purpose of this very point, whether a shareholder can bind company or not, not at all. He can't bind it. Why not? Because he's not the owner. He's not one of the owners, and he has no agency. He has no implied authority from the company to act on behalf of the company. He's not considered to be an agent of the company. That's why no agency. This is another clear difference. This is another clear point of differentiation between company and partnership. Then coming to um, point number 8, which differentiates between the company and the firm. That's management. Who manages the business? The partners themselves. There are 10 partners. Two of them, they say that we will contribute towards the capital, but we are busy people. We can't take part in the active management of the business. Okay, well and good. They can be allowed. There is no illegality. And those people, those partners would be called dormant partners, which are in ordinary English are known as sleeping partners. So what I mean to say is that the business is carried on, business is managed by the owners, and they are the partners. Okay, but shareholders, they do not have such an authority since they are not the owners. Business is managed by management. And what is the who is the management? Management is, they are also shareholders, but they are chosen by the general body of shareholders as directors. So there is a board of directors, and those directors, along with the chairman of board of directors or managing director, they are chosen by the shareholders. So indirectly, shareholders are managing the business in the form of directors chosen by them, but they directly do not take any part. They cannot act on behalf of the company, while directors, they can. Why? Because they are agents of the company. They are the one who actually represent the company or act on behalf of the company. So this is another. And the last point of differentiation between the company and the firm is dissolution. And I have explained it while talking about something which differentiate company from dissolution process is different. You see, a firm can be dissolved anytime just by a notice. But you see, for the dissolution of a company, you see, there is a special procedure provided by the Companies Act 2017, that without that procedure, no company can be dissolved. Okay, and firm can be dissolved at any time. Firm is the result of of a contract between the partners. It is creation of a contract between the partners. In the same way, the same partners can make another contract to bring it to an end and to dissolve it. So these are the points which differentiate a company from the firm. All right. Coming to the classification of companies, as I told you, that there are different kinds, different classes of categories of companies. Companies are, you see, on the basis of incorporation. What does incorporation means? You see, registration of companies is called incorporation. You see, when you file all the documents which are essentially required by the Security and Exchange Commission of Pakistan for creation of a company, that process is called incorporation. So companies are created in three ways. One, I have provided in the presentation all the three ways, although one way has been, you see, discarded now, like in the United Kingdom. You see, companies used to be created by the crown, by the crown. What does by crown means? I mean, the ruler, the king or the queen. They call it crown because they don't care whether a woman is ruling the United Kingdom or a man. That's why they call it crown. So this East India Company, which facilitated the British government to occupy the Indo-Pakistan subcontinent, you see, that was a chartered company. So they used to apply to the crown for incorporation of a company. So that is called creation of company by royal charter. Still, there are, you see, um, they are used to incorporate learned societies, and professional bodies are even today in the United Kingdom are created or incorporated by way of royal charter. But so far as the trading companies are concerned, they are created by registration. Okay. The second way of creation of corporations, corporate bodies, or you see, juristic and legal personalities is the act of parliament. Okay, Bata is a company, service is a company, no doubt. You see, and although calling NAMAL or International Islamic University or the Qaid Azam University, calling them a company is a little bit clumsy, but they are corporate bodies. They are different from their staff or their management. They are imaginary personalities, and all of them have been created by act of parliament. There was an act of parliament which was passed in 1971, which created the Qaid Azam University. And another act of parliament which created the International Islamic University in 1985, which is called the International Islamic University Act 1985, the Qaid Azam University Act 1971. And I don't know in what year this National University of Modern Languages was created through an act of parliament. So all these three bodies, not only these, but you see, Pakistan Telecommunication Corporation, PTCL, OGDC, all these are creation of Act of Parliament. They are companies in a sense. Why? Because although they are not company in the sense of company registered under the Companies Act 2017, but they are corporate bodies. Like I have asked you many times that have you ever seen NAMAL? Have you ever seen International Islamic University? Have you ever seen Qaid Azam University? You see, for a layman, this question is a very silly and stupid question. Yes, sir, daily I see Qaid Azam University. You can't see it. Why? Because it is an imaginary personality. All the buildings belong to Qaid Azam University, to National University of Modern Languages, to number. All the vehicles, buses and cars, they are owned by NAMAL. And whenever NAMAL wanted to sue someone, to file a suit, it will file a suit in its own name. NAMAL versus Mr. So and so. And if Mr. So and so wanted file file a suit, you see, in a court of law against NAMAL, he will not file it against the rector or against the registrar. No, no, he will directly sue NAMAL. So they are these corporate bodies. They are juristic personality. They have rights and liabilities. They can sell and buy in their own names. They can sue and can be sued in their own name. So these are act of parliament. The third, you see, and the most frequent way of incorporation is incorporation through registration, creation of companies by registration. And that registration under the Companies Act of 2017 is conducted by the Security and Exchange Commission of Pakistan. You might have seen the signboard of this commission in blue area. So this is a commission, you see, this is also created by the government of Pakistan for, you see, for creation or registration of companies. Prior to this, years ago, decades ago, you see, there was a corporate law authority or something like that. But that has been elevated into a commission. And now, you see, whenever a company is needed to be incorporated, registered, whether it's a public company, private company, you see, it has to be registered with the Security Exchange and Commission of Pakistan. And there are certain requirements which have to be fulfilled. Only then a company can be created or registered. So registration is the most common used means of forming a company and virtually the only method now used to form trading companies. And let me tell you, I might have forgotten to tell you that, you see, a company might not always be created or registered for trading purpose. It may be for non-profit purposes as well. Okay. So there are companies, lot of companies. Like if you have passed by blue area, you see, you might have seen Security and Exchange within brackets Guarantee Limited. Security and Exchange Guarantee Limited. There are companies which are registered under the same act with the same commission, and they are not for profit, for trade. They are for non-profit. We'll talk about it in detail. Coming to the classification of companies on the basis of members liability. Okay, so companies are either private limited or public limited. A private limited company, you see, which has been defined in section 2 para 49. You see, it defines a public private company as a private company is a company which by its articles. What are articles? In today's lesson, you will come to know that for creation of a company, there are two essential documents which are to be prepared. You see, one is memorandum of association, and the second is article of association. Just for the purpose of this definition, let me tell you that memorandum of association is the constitution of a company. It regulates the company's relation with the outer world, while article of association are the bylaws or regulations for the internal management of the company. So section 2 paragraph 49, while defining private limited company, it says that a private limited company is a company which by its articles, and it prescribes three characteristics which make a company a private limited company. Like it restrict the restricts a private limited company is a company which by its article must restrict the right to transfer its share. In public company, it can they are transferable anytime from anybody to anybody. Okay, but in private limited company, they are not transferable. They are restricted, strictly restricted. One shareholder cannot transfer his shares to another or to an outsider. Number one. Number two characteristic of a private limited company is that limits the number of its members to 50. Number of members in a private limited company must be 50. So a company in which the number of members is 50, you see 50, and it has another characteristic of restriction on transfer of share. It's a private company. Thirdly, it prohibits any invitation to the public to subscribe. So three characteristics of private limited company. Number one, restriction on transfer of shares. Number two, restriction on number of the members, 50. Number three, restriction on invitation to the public to buy the shares. Okay, so these are three you see essential characteristics of a public private company. All right, so it means that a company must have these three. A company, for being a private limited company, must have these three characteristics. It must have restriction in its law, in its articles, that transfers the shares are not transferable. Number two, that it must mention clearly in its articles of association that its members are not going to be beyond 50. Number three, it must restrict from inviting public to buy its shares. So shares are always, you see, offered for sale by public limited companies. Private limited companies cannot sell their shares to the others. So this is private limited company. Now coming to the definition of public limited company. What is public limited company? Section 2, paragraph 42 defines it in a very simple way. It says that a public limited company is a company which is not a private limited company. What does that mean? I mean, is it not funny to say that a public limited company is that company which is not a private company? Yes, It means that those three characteristics which make a company a private limited company, you see, if they are not found in a company, then the company is a, a public limited company. Like, if you see, it does not restrict the right of transfer of share. If in a company the transfer of shares for either from one shareholders to another, or from one shareholders to a third person, if they are if they are not restricted, if there is no restriction upon the transfer, you see, number one. Number two, if the number of members is not limited to 50. Okay, it's a maximum is unlimited. And number three, where it does not prohibit invitation. Okay, I mean, it's not compulsory for a public company to raise its capital from the public by selling its shares to, it's not compulsory. There might be, and there are, public limited companies which do not sell their shares. Okay, but it must be, you see, if it is mentioned in the articles of association that it cannot offer its shares, then it's not a characteristic of a public company. So if a company is a public company, it would not, number one, it would not restrict the right to transfer its shares, and it shall not limit the number of its members to 50. It shall not prohibit any invitation to the public. If these three important elements are found in the documents or in the articles of association of the company, memorandum of the association of the company, this is a public company. Now, I think it's very clear for you to know and explain what a public company and what a private company is, and what are the chief characteristics of these two companies, and you will be able to differentiate between these two. Then number third is single member company. This concept is recent. A single member can a single member have can form a company in his own name as single person. Like Kala Khan, who has got Kala Khan's grocery, Medina Karyana store. Okay, Kala Khan has named his business as Medina Karyana store. So he can go and file the essential documents to convert his sole proprietorship business into a company business you see, by converting his business into a single member company. This concept is recent. Why I'm saying recent? Because when we were doing our LLB in 1981, you see, the law was a very simple law. That was Companies Act of 1913. When I started my teaching in 1987, the law was changed, and the law which we used to teach was the Companies Ordinance of 1984. So there was no concept of you see, a single member company till you see, till before the time of this present law. Although, you see, this concept was conceived and created while the Companies Ordinance 1984 was the law of companies. But now it is recognized, and a single member, a single person can, under Section 14 of the Companies Act, he can form a company. All right. And you see, it would not be improper to tell you that whenever a company is created, it's a newly born baby. A newly born baby has nothing, no money, no food, no clothing, you see. So it has to be provided money for business capital. How it is done, we will discuss it at its proper time. But you see, an existing business can be converted into a company form of business. So Kala Khan can convert his Medina Karyana store into a single member company. But what would be the benefit for him? Many benefits. And I can't go back to my very first lecture in which I compared, you see, a sole proprietorship with the company business. There are a lot of, you see, a lot of merits and lot of benefits to convert an existing sole proprietorship business into a single member company. For that, you would need to go back the very first lecture of mine in this semester, where we talked about the, you see, merits and demerits, advantages and disadvantages of different form of business organizations. Okay, so three companies: private limited company, public limited company, and single company. Then you see there is another classification. As I told you that the companies are not always for carrying on a business. There can be corporate bodies, there can be companies which are formed, created for non-profit businesses. Okay, so the liability of the shareholders, the members, let them be called members. The liability of members of a company is based on their shares, isn't it? Okay, I mean, what can they provide for contributing toward the loss of the company? They can sacrifice what they have invested in the form of business, in the form of shares, buying shares. All right, if the company is at loss and it is wound up, you see, their liability is to pay off for unpaid shares. And their liabilities is that there is a post probability that they would lose what they have invested in the form of buying the shares of the company. All right. So this company is called, and 100% of trading companies, they are called companies limited by shares. Okay. What's the liability of the members? How much would they provide to to repair the loss of the company? What they have paid in the form of the business. All right. As against this, there is a company in which there is no share capital. Every company has got a share capital. You see, these amounts paid by the shareholders in the form of buying the shares of the company, that becomes the capital with which the company, you see, carries on its business. But a company which has been formed for a non-profit purpose, just suppose for the development of science and technology, for the betterment of the Adike Mazdoor, or for the running of an orphan house, etc., etc., for charitable purposes. So that's not a trading company. So it has got no share capital. At the time of registration, the commission will ask him that if your company is at loss, who will be liable for that, because you don't have share capital. So every member is required to guarantee that at the time of winding up of the business, I will be bound to provide this much of money. So if five people are forming a company which is limited by guarantee, and every one of them says, I will provide 100,000 rupees, you see, this type of company is known as company limited by guarantee. And as I told you that this is not these companies are not formed for trading purposes. They are for non-profit person. And all the advantages you see of company are available for this type of company as well. Okay, so the next session is about how to form a company. So for the time being, I'm saying goodbye to you for the next session, and I'll see you after 5 minutes.